Good morning, all. This trial is in the matter of CFI 049-2022 before His Excellency Justice Shamlan al-Sawalehi. The claimant is represented by Suhad al-Jabouri, advocates, legal and consultants. Lead counsel is Mr. Santanu Ghosh. The defendant is represented by Baitul Hikmah Law Firm, and lead counsel is Mr. Mohammed Subhi Salt. Thank you, Your Excellency.
Yes.
Yes. Thank you, Your Lordship. Lordship, before beginning, just one request. The expert has some time constraints. If after the opening submissions, his cross-examination, because I will just take 2 minutes to take his chief examination in chief, and if his cross-examination can be dealt with, we'll be grateful.
Yeah, no worries.
Thank you, Your Lordship.
Your Honor, if I
you.
may,
Yes.
as per the RDC rules, the witnesses of the expert witnesses are supposed to be heard after the witnesses of fact. Our primary witness has a prior engagement at 2 o'clock.
So you don't have any then agreement between both of you?
No.
We should start first. Yeah, what you say, Mr. Yes, shall we go with the rule book?
I mean, I cannot object to the rule book, so
Yeah.
that's
Yes.
so. Yeah.
I think yes, much better. We'll go as just Mr. Muhammad described. Yep. Okay.
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
So once again, before starting, we had filed an application which was quite late actually on the 27th of this month, and it got further delayed due to some, I believe, technical issues of the registry where the payment was not recorded on time, though it was paid on the 27th. That's why we did not include that in the trial bundle. It was regarding the computation of loss, which we, Your Lordship, had discussed on the last day. Now, as on date, it's not in the trial bundle. So I leave it to Your Lordship if that particular document shall be treated, I mean, only on paper without any hearing after Mr. Mohammed submits his objections to it.
Well, if it is not being filed in the bundle, then of course the other side didn't get the chance to look to it and reply.
Yeah, it was only, and the application number was registered only day before yesterday, Monday. That's why it has been served on the opposite side, but we didn't, deliberately we didn't put in the bundle because without Your Lordship permission, we cannot do that. So it was just, he didn't have any time. I mean, the defendant, of course, didn't have any time to respond to it. It was only on Monday.
But
so
it was filed on time or out of time?
It was filed on the 27th.
What was the deadline?
There was no deadline, just Your Lordship had mentioned that as fast as it could be done.
We'll see what we're going to do about it. Maybe we'll give of course, the other side opportunity to
yes,
to reply later on after post-submission, post-hearing, but we'll see how it goes. Yes, please go ahead.
Yes, yes. So I'm appearing for the claimant. The brief facts of the case are the claimant executed 2 transactions with the defendant. The first one being Egyptian pounds treasury bills purchased for USD 999269.05, which was confirmed by the defendant. And the second transaction was for USD 1,359,000.
Just sorry. Are we still need the 2 days? I just wondering, are we going for 2 days hearing?
No, 1 day only. 1 day. Today we are going to finish.
It seems to me it's booked for me for 2 days. I'm not wrong. Yeah. So in my calendar it's 2 days, but you're confirming only 1 day you need, yeah?
Yeah, I mean, both the parties have already submitted the timetable to the registry for 1 day.
I don't know why it's in my calendar is 2 days. Thank you. Thank you for confirming. Yes, please.
Yes.
Sorry for interrupting.
No issues. So the second investment was for an amount of USD 1,359,063.87. A total amount of 2,358,332.92 USD was invested. Now, on 14th of March, the claimant decided to exit both the transactions, and accordingly, the defendant also submit and provided an exit calculation, which also had an exit date, which was 17th of March. Ultimately, we did not get the amount, or the claimant did not get the amount on 17th of March. After consistent and persistent follow-up, and even after sending a warning letter on the 23rd of March, on 24th of March, a certain amount was credited, which fell short by $357,116.66. The claimant's submission is that several follow-ups happened from 17th of March till 23rd of March, but the defendant did not explain why the amount was not credited on 17th. Whether there is a shortfall or not, that's a secondary issue. The first issue is the amount should have been, whatever the amount, should have been credited on 17th of March. There is no explanation on that. The second is, we are well aware of the risk disclaimer clauses, even knowing fully well that on 17th of March, if an amount was to be credited, it would have been less. That was the initial discussions which had happened on 14th of March based on the document which was also produced and confirmation. Then, in view of that, we believe that the bank was in serious negligence of its duty towards the claimant. They did not explain very well or properly at all the reason why the amount was neither credited on 17th of March, 18th of March, 19th of March, 20th of March, 21st of March, 22nd of March, and 23rd of March. And there is no explanation why it was credited on 24th of March. So we believe that the defendant owes a duty towards the claimant, which the defendant failed miserably. The defendant is liable to compensate the claimant, not only the amount, which is the shortfall amount, but also damages. That's all. That's the brief submissions.
Yes. You want to continue with your submission, or that's it?
No, that's it. That's the brief submissions.
Okay. Thank you.
So,
So you want to rely on any other rules, or
I'll do it in the closing submissions.
as you like, whatever you like.
Yeah.
Are you gonna? Do you want to take me to any electronic bundle to show me any submission, any evidence?
So after the cross-examination of the single witness on the closing submissions, I'll certainly take you to those bundles.
All right. Okay. So, Mr. Muhammad, for your brief submission, as
Thank you, Your Honor. If the court will accept it. Thank you, Your Honor. If the court will accept, I would like to go into maybe a little more detail in the opening submissions by pointing you to parts of the trial bundle with the court's permission.
Yes.
Thank you, Your Honor. The claimant has argued that this matter has argued breach of contract and negligence in its particulars of claim. In particular, my apologies, I need to introduce myself. My name is Mohammed Suki Salt. I am counsel for the defendant. Sorry, yes. The claimant argues that this matter is a straightforward breach of contract and a negligence claim. It relies on articles. Sorry, let me just pull up my bundle. It relies on, it claims a breach of contract pursuant to Article 64A and Articles 83 of the DIFC contract law. It then claims in the alternative that the defendant acted negligently, giving rise to a negligence claim under Article 17 of the DIFC law of obligations. The claimant, if we can summarize this dispute, treats an email that was submitted by the defendant on the 14th of March, 2022, which is at page 35 of the trial bundle, tab B6.
Yes.
it treats an email from Mr. Al-Mu'taz Mohammed Helmi as a confirmation, as a binding confirmation that an agreement would be, that the investments would be exited on the 17th of May. What the claimant neglects to mention is the language that comes under the exit calculations, which states that the entirety of the EGB-TB exit calculations for early redemption are subject to change on market conditions.
Yes.
Yes, the claimant is attempting to frame this transaction, the entry and exit of the trade bonds, as a relatively straightforward, in very straightforward buy and sell terms. The defendant asks that the court not lose sight of the fact that this matter was a transaction in US dollars to Egyptian pounds, which means that everything has to be looked through the frame of US dollar, the conditions for the market conditions for US dollars in the Egyptian markets. The claimant will draw the defendant draws the court's attention to the confirmation emails for each of the investments, which I'll be referring to as investment 1, which was on the 14th of October, 2021, and investment number 2, which was on the 2nd of March, 2022. These documents can be found from pages 37 to 40 of the trial bundle. So it would be tab B7 and B8.
Mm.
These are all sideways. 1 second,
Yeah.
please. You may find a clearer copy at page 107 of the trial bundle.
107.
Yes.
Yes.
Now, for each of the investments, the court will note that under the tables for both investment 1 and investment 2, there are disclaimers that state that final net yield on principal is assuming same FX conversion rates at the entry and exit dates, today's Banque Misr U.A.E published rates, final USD Egyptian EGP published rate, 15.6 Banque Misr U.A.E USD Egyptian ask rate at the maturity date, and final net yield will be determined at the liquidation maturity date based on the final USD EGP foreign exchange reference rate. Now, what this matter ultimately and on the breach of contract basis revolves around is the market conditions on the for US dollars. These are risks that the claimant was informed of by way of a general risk disclaimer, which can be found at tab D3, page 85. Yes, page 85, which talks about investment risks, early redemption risks, issuer creditor risk, market risk, foreign exchange risk, and interest rate risk, among other things. And is also alluded to, or actually directly referenced in the Master Agreement, tabs 7.3, Article 7.3 and Article 16, which can be found, the Master Agreement can be found, a clear copy of the Master Agreement can be found on pages 94 through 106, with Clause 7.3 at page 101, and Clause 16 at page 104.
Yes.
The claimant argues in its exit, argues that the email, the exit email, the one stating that condition it dependent on market conditions, dated 14th of March 2024. As I understand the claimant's argument, is that the exit confirmation amounted to a promise or a guarantee that exit would be effected by the 17th of March. However, that is not the case. The wording in the disclaimers make it very clear that an exit would be subject to market conditions. When the claimant stated, please proceed, which can again be found on page 35, tab B6, it did so without any modification to the terms of the exit. So what does this mean? It means that the claimant accepted that the exit was subject to market conditions. The exit date and exit calculations are not concrete or set in stone. The exit date was one that was not unconditional. The claimant relies on the claimant bases its argument on in breach of contract on the basis of clauses 3.1 and clause 1.6 of the master agreement. Clause 3.1 can be found on page 97, and clause 1.6 can be found on page 96 of the master agreement. So Article 3.1 of the Master Agreement states that each party shall discharge the payment, delivery, and other obligations owed to the other party no later than on the due date specified in the confirmation. And the confirmation is defined as the written notice, including telex, facsimile, or other electronic means which contain the specific terms of transaction entered into between the parties. Ancillary agreements referred to in the confirmation are the part of such confirmation. The defendant rather, submits that the disclaimer language in both the entry into the investments and at the exit of the investments highlights the conditional nature of any entry or exit of any investment. The claimant was aware of this. Again, we will refer to the general risk disclaimers, which again are found at page 85 and 87. The first paragraph of the general risk disclaimer states that the investor should understand the nature of the risks associated with each and every risk factor outlined below and should obtain relevant and specific professional advice before making any decision. The list below does not, however, claim to be a complete list of all related risks. The investor assumes all risks associated with any decision it makes and shall have no rights against Banque Misr in connection with such decision. The risk disclaimer then, as I mentioned before, goes through several of the non-exhaustive list of factors that must be considered in any investment. I submit that I will not take the court's time in reading out the specific wording, but the key takeaway is that the signed general risk disclaimer shows that the claimant has agreed to assume all risks associated with any decision it makes and shall have no rights against Banque Misr, the defendant, in connection with such a decision. That the claimant has read and understood the investment risks involved in financial products, such as Egyptian treasury bills, including without limitation the nature and extent of their exposure to risk. The claimant has read and understood that if it sought to redeem the Egyptian pound treasury bills it invested in prior to maturity, this may result in it receiving an amount less than was originally invested at inception, and that the redemption of value of the investment is a function of fees, the price and volatility of the underlying assets, time to maturity, and prevailing market conditions. It also shows that the claimant has read and understood that there is a market risk in any investment it makes, which may include changes in value and volatility of any underlying assets, and changes in economic, financial, or political environments may result in fluctuation of prices, and that such risk may cause the value of an investment to fall rapidly as well as rise, and investors may not get back the amount originally invested. It also shows that the claimant has read and understood that there are many foreign exchange risks involved in any investment it makes through the defendant. This is especially pertinent in light of our submissions in the statement of defense, particularly paragraphs 10 through 14, and I will ask that the court take note of those paragraphs. The statement of defense can be found on pages 67 to 79 in tab D1. In the paragraph of the general disclaimer entitled Foreign Exchange Risk, the defendant clearly states that the exchange rates may fluctuate significantly over a short period of time, diminish investment value, and cause loss of principal relative to the home currency. The defendant also clarifies that this risk applies to assets denominated in foreign currencies, such as this investment, which was, again, we must remind the court, done in US dollar terms for Egyptian pounds. And I will explain the significance of this shortly. The defendant also clarifies, I'm sorry, I lost my train of thought. in foreign currencies and traded in domestic currency, since their price development usually tracks changes in exchange rates of the currency in which they're denominated, such as Egyptian pound treasury bills, which it had invested, and that the investment has read and understood that there are emerging market risks involved in investing in Egyptian treasury bills, which include social, economic, and political uncertainty, dependence on exports, and the corresponding importance of international trade and commodities prices, currency rate fluctuations, and so on. Given that the position of the defendant is that given that the claimant has read, understood, and signed off on the risks in dealing in Egyptian pound treasury bills, as set out in the general risk disclaimer and clause 7 of the master agreement, including but not limited to investment risks and early redemption risks, and has agreed to assume such risks, and has expressly agreed that market conditions may make it impossible for an investment exit to be effected immediately, as per clause 16, and expressly stated that it is financial position to bear substantial losses regarding to any investment, it cannot hold the defendant responsible for loss arising from risk factors it is acknowledged. Now, on the point of negligence, the defendant's argument is relatively more straightforward. In order for a negligence claim to exist, according to Article 17 of the Law of Obligations, let me just pull this up. The claimant must show that it was owed a duty of care, that there was a breach of the duty, and that the breach of the duty caused the claimant harm. The defendant submits that beyond just stating there is negligence, the claimant has not shown that it is owed a duty of care. It has not showed that there's been a breach of said duty, and it has not shown causation. For these reasons, we believe, the defendant believes, that the claimant's claim in both breach of contract and negligence must be dismissed. Thank you, Your Honor.
Thank you. I just want to ask, investing in this type of bonds, treasury bonds, especially with Egyptian bonds at that time, with all those political surrounding the Egyptian bonds, this investment was not insured, or there is no any offer to insure that investment. So there is no any insurance was associated on this particular investment offered by the defendant or us by the claimant.
I cannot speak for the claimant. But I have not been instructed on this point.
The reason why I'm asking this question is because if the claimant was already aware of this high risk, as you alleged, in this type of investment, and I know I've seen, of course, those provision which is related to give alert to the investment. There is going to be a high risk, and he's aware of the high risk. But then he should take like a kind of insurance, policy, or have to thinking of enter to this investment with type of insurance. So if he lost, then the insurance company will cover his cost. But it seems to me that that solution was not on table at that time, maybe not being asked by the claimant, or wasn't being offered by the bank. And this is why, for me, it's a little bit unusual situation. But anyway, here we are. I'm just throwing this. I thought there is going to be an answer, but as long as nobody was considering to insure this investment early days, then maybe it wasn't the case. Okay, what do you want to do next? You are muted, Mr.
I'm sorry, Your Honor. Yeah. Yes. The first witness, the only witness actually, apart from the expert witness, Mr. Walid.
Do you have any comment on my insurance point, Mr. Santos?
Even I do not have any instructions, but I believe there was no insurance. I mean, neither from the claimant side nor from, I don't know whether
Yeah.
from the defendant side. I have no
Yeah.
instructions actually.
The only things maybe I need your reply or your comment on about this, the claimant being aware of all of those high risk when they enter to this investment. Are you going to address me on this later on?
Yes, of course, of course.
Okay.
The main issue here is not about the risk. Of course, we are aware of the risks and we have submitted in the witness statements also in the particulars of claim also. The point was the risk higher on 17th or was it higher on 24th? Or in between 17th and 24th. There was no information from the bank that if you diluted it today, then you will get a lesser rate and the amount will be less. Neither was any confirmation on 24th that today we are crediting the amount, so you will be getting this amount less. So do you want to continue or not? That's the main issue. So,
okay. So what do you want to do now?
So we are producing our first witness, Mr. Walid. He's already there. I will request Mr. Walid to switch on his camera and Lordship, while the witnesses will be cross-examined, I believe the opposite side witness should not be present.
Mr. Muhammad, comment?
It was my understanding that it's only the other defendants of the other witnesses of the claimant that were not to be present for this hearing.
That's only the expert. I mean, expert can move out, of course.
Okay, so let's do it in the usual way.
I'm not very sure whether the expert is here now. May I just take instructions from the solicitor?
I don't know who's attending. It's for me. It's as well. It's like a. I don't know. I cannot tell from the attendees
Your Honor,
who's who.
For the defendant, we have two attendees for the for the defendant. I have my colleague Ahmed Subhi, who is assisting me on this matter, and Mr. Muattaz, who is the Mr. Mahmoud Muattaz, sorry. Mr. Mahmoud Al-Namr, who is legal counsel for the defendant, and Mr. Muattaz, who is the witness for the defendant. The other 9 attendees, I believe, or 8 attendees are all for the claimant. Yeah, I will just wait for instructions from Your Honor to ask me to, if you'd like for me to ask Mr. Muattaz or Mr. Mahmoud Al-Namr to drop off this call.
Do we need them to drop off this call?
He's the other witness.
Mr. Muattaz is the witness for the defendant, yes.
No, he can stay. I mean, that is, I think you are right, Mr. Mohammed. Claimants, other witnesses cannot stay. So that was a mistake from my side. So you can always stay. From my side, Andrew Menon is representing the solicitor. I don't know who is Devika Ratnaik is. And Mridul is my junior who is attending.
Devika is my judicial assistant.
I'm sorry, Your Lordship.
Yes.
And Mr. Walid is there, so and nobody else, I think, belongs to the claimant here. The expert is not there, so there's only one witness, Mr. Walid, who has now switched on his camera.
Sorry, yeah. Okay, then let's proceed.
So, Mr. Walid, you need to take a note.
Yeah, the registry should.
Mr. Walid, can you switch on your microphone?
Yes. Assalamu
So,
Good morning, Walid. Can I please confirm if you would like to swear on oath or by affirming?
I'm sorry?
Can I please confirm whether you would like to swear on oath or if you would like to affirm?
No, I confirm I will swear, no problem.
Can I please have a copy of your holy book in front of you?
Yeah, yes, sir.
Thank you. Can you please confirm your name and occupation for the court's record?
I am Walid Salah Ruiz. I'm the owner of the company Vision Construction.
Can you please repeat after me?
Yes.
I swear by the Almighty God.
I swear by What? Can you talk by Arabic better, please, if you can?
Yeah, it should be in English.
Okay, sorry.
I swear by the Almighty God
I swear by my Almighty God
that I will say nothing
that I will say nothing
but the truth.
but the truth.
Thank you, Your Excellency.
Thank you.
Thank you.
Yes.
Yes. Thank you, Mr. Walid. Good morning.
Morning.
Do you have the trial bundle in front of you?
Yes. By English.
Can
Yes,
you
I
come
have.
to, yeah. Can you come to page 189, 189? This is your first witness statement.
189.
Yes, 189.
Wait. Page 189, huh?
Yes.
Yeah, tell me. I will open, but tell me.
Yeah, you please open it and come to page 190.
189. Okay, I will open it. Sorry.
You have it in front of you?
No, I am opening it now.
Okay.
Yes, sir. Yes. 189. Yes.
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 So please come to the next page, 190.
Yes.
Please confirm from the first paragraph whether your name, your passport number, and Emirates ID is correct.
Yes. Yes.
Okay. Please confirm that whatever you have mentioned in this witness statement is true to your knowledge and belief in the last page of the witness statement.
Okay.
Which is at page 194.
Yes, my sign. Yes. Yes.
And this is your signature.
Yes, sir. Yes.
Thank you.
Yeah.
Yes, Your Lordship, this is in brief. So his examination in chief sets out in details, which I don't want to take the time of the court. I leave it to Mr. Mohammed for cross-examination.
All right. Thank you. Mr. Muhammad, please go ahead.
Thank you, Your Honor. Mr. Walid.
Yeah.
Let me just pull up your statement here.
But maybe before you go ahead, I just want to give an instruction to Mr. Walid.
Yes.
Mr. Walid, thank you for your coming today. And just as a general instruction, when the council asks you any question, so you need to answer that in brief. If you want to give a more details, then you can ask permission from the court for more detail, because sometimes witness, they answer the question in different way, or they not really answering the question, and they come up with another answering. So if you didn't understand the question, you can ask the counsel to repeat the question. He might repeat it in different way. So this is just a brief instruction, so I hope you can cooperate with us.
Thank you.
Thank you. Sorry,
Yes.
Mr. Muhammad.
Yes, Your Lordship, just before Mr. Mohammed starts, Mr. Walid, there is a second witness statement also, which is on record at page 125. So if you can open that second witness statement and confirm that the first your passport number and details are correct in the first page.
Yeah.
Page 125.
Yes. Yes, sir. Yes. Yes.
Yes. And you confirm that whatever you have mentioned in the witness statement is true to your knowledge and belief, and your signature, that is your signature.
Yes, my signature. Yes. Yes.
Yes.
Thank you.
Thank you.
Thank you.
All right, Mr. Muhammad, the witness, yours.
Thank you, Your Honor. Thank you, Mr. Walid. Mr. Walid, I'm not going to take too much of your time, I don't think. I want to draw your attention to paragraph 15 of your witness statement on page 192.
The first one or second one? Yeah. Sure.
Oh, my apologies. Your first witness statement.
Yeah. So give me the page number 192,
192, please.
192.
is the relevant paragraph. The witness statement itself runs from
Yes.
page 189 to 196. Mr. Waleed, you say that
Which
no
one?
amount
Which one
was.
is this one?
I'm sorry, paragraph 15, Mr. Waleed.
Yes.
Yes. You say that on that you met with or contacted your relationship manager on the 17th and 18th of March 2022, to which the relationship manager assured you that the amount would be released as due. Do you have any proof of such meeting having taken place?
Proof for calling yani or what? I just call him. Proof like what yani? I just calling.
So you have no records of the phone call, no recordings of this phone call.
No, I've not recorded my phone. How come? You need some recording from Etisalat or something, yani some report for that?
No, Mr. Waleed, just drawing your,
If you want, I
drawing
can
the
bring.
court's.
If you want, I can bring something like that. If you want.
It's quite all right, Mr. Waleed. The time for that has passed. Now, you also state in paragraph 16 that you met personally with your relationship manager and Mr. Hussam, the superior of the relationship manager, and both again confirmed the redemption value of US dollar 237,817.83 that would be in the account of the claimant on the same date. Again, I have to ask, where is the evidence of such a meeting having taken place?
Can you repeat it
Or
again?
let me rephrase that. Mr. Waleed. Is there any proof that a meeting had taken place between your relationship manager and Mr. Hussam, the superior of the relationship manager?
Proof for meeting? I don't have proof for meeting, and how can I prove it? Anyway, I send after that next day. I send mail from my mail to Hussam and for Mu'taz. I send for Mu'taz, Mr. Mu'taz, my RM relationship manager. I sent for him to confirm that meeting, and he already that mail is there already.
And
After finish the meeting because this is already I have too much time long. I have doubt. I send one mail for them by the meeting and by the amount exact amount.
And is, to the best of your knowledge, or do you know if that email was ever?
I'm sorry. This is when you tell me proof. When I finish the meeting, the same day I send one mail by the amount and by the regarding the meeting. And nobody reply. If you have doubt, if you have problem for that, if you have something wrong, he should to reply me. I'm not. This is official email. He should to tell me no, this is not correct. Whatever in meeting, he can explain to me exact what. If you have any comment for the amount, if you have any comment for the meeting, maybe this proof. When I finish, what I will do. I'm not. I can't prove more than. When I finish the meeting, I send same day one mail by details. If you have doubt for that, if you have problem for that, he tell me, I will see, I will do whatever, like that. Our mail, it's officially in
Yes.
our agreement, in main agreement.
Mr. Walid, I think you made your comments very clear. So let the council ask you the following question. Thank you.
So, Mr. Waleed, you are, I don't know what basis on which you believe the defendant owed you a duty to reply to your email, but let me ask you a question to illustrate the point I'm trying to make. Now, Vision Construction, this is your company, correct?
Yes.
Yes. And in your construction contract, say with your subcontractors,
Yes.
for example, if you're purchasing things from your subcontractors and you have a meeting with your subcontractors, is it normal or industry standard to have the subcontractor say, this is what happened in the, what would be your reaction? Let me rephrase this. If I were to say, I were your subcontractor and I sent you an email, just on any other day, following a meeting I had with one of your junior associates, saying, yes, we agreed that you're going to purchase products from me for 100 million dirhams.
This is normal. I do before 2 transactions with Banque Misr. If normal, it's almost 1 day or 2 days maximum, the amount coming in my account.
Mhm.
If I attend any I will come back to your example for subcontractor.
Mhm.
Normally, if subcontractor have any doubt for too much time, he not get his payment for anything, in that time he need to prove whatever done in the meeting. We need to prove because he have doubt already. Normal, I sent the mail in 15 March. And up to 23 months, up to 23 or 21, I'm not get that money because that I have too much doubt. And also in 21, the current change, the price change. Because that I need to prove already I attend the meeting and we are already confirmed for that. Only for
Actually,
that, if normal, I'm not do that. If I got the money normal time, I'm not do that. I do this mail before any change. If you see date of the mail.
sorry,
I don't think we didn't go to this one.
Yeah,
Just
Mr.
you need to answer the question brief. So
Yeah.
don't follow the
Yeah.
question with another question from your side.
I'm sorry. Oh, he asked me for a question for subcontractor. Subcontractor, if anything abnormal, sure he need to prove by mail by any minutes of meeting for our meeting.
But to clarify this, Mr. Muhammad, I think the witness sent an email to the same people who he met with, not with. It's not like he's meeting with someone else and he's sending email to their manager. I believe he sent the email to the same people who met with to confirm what's happening during the meeting. That's all.
Yes,
Right?
Your Honor, I understand.
Yes.
Yes, Your Honor, but
Now
if
you
I
have
may.
doubt. I understand. You have doubt that what he was saying in the email, it didn't took place or didn't been affirmed by the bank manager. I understand that.
Okay, Your Honor, I'll move on. I'll move on,
Yes.
Your Honor.
Thank you.
So, Mr. Waleed, I just wanted to talk about the timing of the decision to exit. You stated that you were exiting on you decided to exit the investments on the 14th of March, having entered into one of the investments on the 2nd of March. Please, could you elaborate as to the reasoning behind the decision to exit?
This is we deal with this treasury as a gold, as a goods, as a any material. We suppose it's like gold. If I feeling this price coming down, I will be re-exit before. Like even when I ask that exit, I lost on this exit. As per his schedule, already I lost some amount, but already everybody knows that this is market. And you tell me, you tell already this is risk. I know the risk. I respect that risk for this treasury but as per our agreement, it should be maximum 3 days to take action for that. For when I give him instruction for that, and he should to give me confirm. Yeah, he should to give confirm for the rate for everything.
Okay, can I turn your attention to a letter that you had written to Banque Misr, dated the 23rd of March, 2022. It's in the trial bundle. It will be tab B4 from page 29 to 33 of the trial bundle.
Before? What is this?
Yes, tab B4. It's exhibit quite. It may be a bit confusing, but it's actually exhibit A9 to the particulars of claim. It is a letter from Vision Construction dated 23 March 2022 to respected Banque Misr, Dubai.
For me, it's confusing as well because the bundle page number, the red color is confusing.
Yes. So if you have the bundle open, if you have the trial bundle open, the page that you should type in at the top
29.
is before
29.
is page 29. Thank you, Mr. Santago.
What is this? What is this?
Yeah, 29.
So you have to type 29 on the top on the search
Yeah,
button.
I got it, but I just want to make the witness he got
Yes,
the
I'm
page.
asking the
I'm not got
witness.
it. I not got it. I'm sorry. Where is this? 29?
So Walid, type 29 on the top where there is a space for searching on the top of the trial bundle.
29.
Yeah, just type out 29 and then click the
I
button.
think he's working from a hard
Anyway, I'm
copy.
not get it, but I know the letter which I sent for Banque Misr. Tell me what your question, please.
Okay. Well, in this letter, you write, it says, attention, Mr. Muattaz, subject, warning about the delay in returning the amount of the bond investment. With reference to the above subject, and where I have previously notified you on 14/3/2022 of the return of the amount of the bond investment, in brackets T_bill, and despite the passage of nearly 10 days without paying the amount. And since we urgently need the amount claimed in our commercial dealings, and any delay would harm us and miss out on certain profits. Therefore, we warn you to quickly return the amount of bonds and hold you responsible for any delay or damage caused to us.
Yes.
Now, Mr. Walid, on the one hand, you are saying that you've treated this investment as a gold, as something that you can buy and sell, and as a pure investment. So I'm just a bit confused. Is it because you needed the monies from the investment for urgent commercial dealings, or is it a matter of I was losing money and I wanted to exit?
This is because already I tell you I make 2 transactions. Normally it coming same day or next day. But now
Mr.
10
Walid,
days,
that's not the question. With respect, that's not the question.
you tell me why I sent the letter, yes?
No, I'm asking what was the purpose of the sale? Are you affecting the sale because you wanted to make a profit, or are you affecting the sale because you urgently needed the amount for your commercial dealings? As per your letter.
As per my letter, I need to use the money already. I have many activity. I don't have any this activity only. I have developer. I have construction. This is I need our money. I don't get the purpose for the questions. Can you explain to me again?
Okay.
Sorry. Yeah.
So,
Yeah.
the claimant in this action is Vision Construction, which you
Yeah.
claim to represent.
Yeah.
Now, you are saying just now in your oral witness testimony,
Yeah.
you stated that you are treating the investment as gold, so it's a store of value, and that you make a profit and or a loss on
Yes.
your investment.
Yes.
So I compared that to the written document that you've provided, which states that we needed this money for our commercial dealings. So I just need you to clarify, what was the purpose of exiting the investment? Why was it urgent? What were
why I
urgent
exit for
needs?
that investment? Because okay, this is already there is. You just now I tell you this is like gold. Gold come up down, come up, come down. It's normal. But when you which time you sell, which time you come back, this is a selected
I
time.
think, Mr. Walid, the question is why you wanna exit from this deal right now when you send that email? Because you are short of cash and you want cash for your business development, or you want to reduce your loss because you notice there is a loss in the bonds value. So this is the question: if
because they're reducing the loss.
reducing the loss.
Yes.
Okay.
It's not because you need the cash and the company need the cash for another purpose. So just because you notice there is a loss and you want to reduce or stop the loss, right?
Yes, sir. Yes.
So Mr. Muhammad, did he answer the question?
He did.
Okay.
I just wanted to. So you were aware then that there is an emerging market risk. You are aware that any investment you may lose money. This is something that you are aware of, correct?
Yes, I'm aware about it. But when you sold, when you get it, your money back, this is I think I can explain for yani already. When I give him an instruction, he should tell me I will sell your gold by this amount. I know you accept or no. It's my gold. Finally, it's my invest, not his invest. He should to give decision by my instruction. When I give him instruction, I give him instruction by exact amount.
Muhammad,
And when you,
Mr. Walid, sorry, please give a short answer first.
Sorry.
Then, if the council want more clarification, he will ask you for those
I'm sorry.
clarification.
I'm sorry.
thank you, Your Honor.
I'm worried about the risk. Yes, I'm worried
Yes,
about the
thank
risk.
you.
Yes.
Thank you. So you were aware in every confirmation that in any communication that you had with the defendant that there were extensive disclaimers at the bottom of every email, correct?
Yes.
And you read and understood those confirmation, those disclaimers, correct?
Which confirmation?
If I can draw your attention to tab D6, page 107 of the trial bundle.
Yes. 107. Yes.
Yes.
107.
107. Just next page is 108. 107 is a cover page. The
Yes.
document is 108. If you can then go to page 109, at the bottom of the email, can you please read out the paragraph starting
Well,
with
Mr. Muhammad, he's not here to read out. Just ask him the question, please.
Okay, thank you.
You
Apologies, Your
can
Honor.
bring his attention to any lines.
Thank you, Your Honor.
Yeah.
So are you on page 109, Mr.
Yes.
Walid?
Yes.
So do you see the words that say net yield will be determined at liquidation maturity date based on the final USD EGP foreign exchange reference rate?
Final use. Can you repeat it again? Which can you
There is
repeat?
a red color. There's a red color sentence. I think then you can
Yes.
take it from there. Today's Banque's Misr U.A.E published rate, and under that.
Yes, sir. Yes, I got it. Yes.
Yes. So you confirm that that wording is there. The final net yield will be determined at the liquidation maturity date based on the final USD EGP foreign exchange reference rate.
Yeah, I read it. Yes.
Okay. Yes. Okay. And this is also repeated in the investment for the 14th of October. I'm not going to take too much. I'm not going to labor the point. It is on record. It is a matter of record. Okay. Mr. Walid, I just had one more question for you. Have you invested in Egyptian treasury?
No, but
pounds?
before this question, what do you need him from take him to this document? What, just him to understanding that line, or what's your question?
My apologies, Your Honor. My
Yeah.
apologies, Your Honor. My apologies. So, Mr. Walid, having now the final net yield will be determined at the liquidation maturity date based on the final USD EGP foreign exchange reference rate. Please, can you tell me, what do you understand that sentence to mean?
What you want to understand?
How do you understand the sentence? The final net yield will be determined at the liquidation maturity date based on the final USD EGP foreign exchange reference rate.
As per rate of my instruction, the rate of the pound in that day when I give him instruction for that. This is the rate of exchange.
Ms. Walid, I don't think that's right. I'm going to draw your attention again to tab B6, which is page 35 of the trial bundle. I
Sorry, give me
apologize
the page again. Page
35.
35. Thank you. Yes.
Are you on page 35, Mr. Walid?
No, not yet. Yes, I got it. Yes. Yes, sir.
So in red, under the table, which reads, Dear Mr. Waleed, in red, do you see the line that says, noting that the whole EGP-TB exit calculation for early redemption are subject to change upon market conditions?
Yes, sir. I tell you.
Okay.
I mean it.
Just a moment,
Yes, sir.
if I may.
Yeah.
Do you understand that language?
Yes.
Okay.
But here, this is okay. Can I repeat? I reply, Louis, please. This is limited time is there for my instruction up to maturity date. And when as this one not forever. So now the rate not like before 1 year, not like before 1 month, not like before 7 days. The rate it changes every day. But as per our agreement, it's maximum 3 days, not more than that.
I'm sorry, Mr. Waleed, where have you drawn
the
3
citizen
days
not
from?
open, yeah, Mr. This is the citizen not open for time. This is related to time. This price here related to time, not open.
No, Mr.
Waleed,
Waleed, if you just maybe there's confusion here. He's asking you if how do you understand this notice?
Okay.
When it is said, when it say change upon market conditions, and market condition, it didn't say here 3 days time.
Yes.
And I don't know where you come, and he asking you where you get this 3 days from.
From where? From my instruction.
Yeah, but this sentence doesn't suggest the period time for 3 days.
No, already we have main agreement together. We have main agreement, and as per our main agreement, we before we do any this transaction, there is main agreement we sign together. If you want, I am not. I don't know where I get it now, but I can mention that for maybe my legal. He can mention in.
Sure. So you are replying to the witness by saying you understand that, but within a cap 3 days, not for open.
Yes.
Okay. So would it be fair to say that?
Can I get water, please? Sorry.
Yeah. Yes.
Yes,
sure.
of course. Yes, of course.
Take your time.
Thank you.
Thank you, Ms. Waleed.
Yes, sir.
Ms. Waleed, I just had one more question for you. Have you invested in Egyptian Treasury? Do you have a history of dealing with Egyptian pound treasury?
Yes.
And a history
even I have it. Even I have it by another bank, with another bank, and I make exit same date of.
Mr. Waleed, that's not the question. That's not for us to talk about. It doesn't involve this party. No, Mr. Waleed, it doesn't relate to the parties in dispute.
Okay.
Now, Mr. Waleed, and you said you've invested in Egyptian Treasury bonds in the past, and with US dollars as well. Is that right?
Yeah, sure. US dollar, yes.
Okay, so you are aware that every time you were investing in these Egyptian pound treasury bills with US dollars, you understand that the transaction requires an exchange from US dollars to Egyptian pounds?
Yes.
Okay, and you understand that when a sale is effected, that the Egyptian pounds need to then be reconverted to US dollars?
Sure, I understand.
And you understand that that sort of exchange is, subject to fluctuations in the market? Fluctuations and
yes.
And availability of US dollars?
Yes, sir. Availability?
Availability of US dollars.
What does that mean, ability? Ability, it's not, I go to bank, it's available or not, it's not my issue. What availability? I don't get this.
But Mr. Walid, you accepted that the availability of US dollars was a market risk and an emerging market risk. So I don't understand why you're saying it's not relevant.
Ability. I'm not get you what availability. What is that?
The availability of getting US dollars for Egyptian pounds.
I'm not. I don't know what that means, but I don't know availability.
So every time the treasury bonds are sold,
Yeah.
They are sold in Egyptian pounds, correct?
Yes.
And the money that is generated from the sale is in Egyptian pounds, correct?
Yeah.
Your account is in US dollars, correct?
Yes.
Okay. To get the Egyptian pounds into your US dollar account would require a conversion subject to the availability of US dollars in the Egyptian market, correct?
Yeah.
You understand this? And you accept and agree that this is a risk that you have onboarded in this transaction, correct?
Yeah.
So you accept that.
Yes, sir. Yes. Yes.
Okay. So okay. Thank you, Your Honor. I have no more questions for the witness.
Okay. Thank you, Mr. Walid. Our Mr. Yeah, I think your witness can be dismissed now.
Can I add something? I'm sorry.
I don't know. Do you need him to add anything?
The defendant, on the defendant's side, no.
So just one question to Mr. Walid,
Yes, sir.
if Your Honor allows me.
Yeah, go ahead.
The exit date which you decided along with the bank, or both the parties decided, was 17th of March.
17th of March? 14th
Yes.
of March. 14th of March.
No,
Yeah.
14th of March, you requested the exit.
Yes, sir.
And the date fixed in the document is 17th of March.
Yes.
So did you get any intimation from the bank that why they are not crediting the account on 17th of March?
After 17, I got this 3 days it finished, and I called him. He tell me, don't worry, it will come. It will come your bank. Don't worry. He confirmed for me. It will transfer by same amount which we discussed already.
Okay, thank you. No more questions.
Can I add it? I'm sorry. Okay.
Yeah. I don't know if you want to clarify anything of what you have said so far. Then we'll come back to Mr. Muhammad if you need to reply. Go ahead, Mr. Walid. What do you want to say?
Yeah, this is I need to explain in same times, same date. I exit from Banque de Cairo, and this bank is belonging to also Banque Misr. And same date, 13, I got.
Whatever. Let him say. I mean, whether by end of the day we can estimate what is relevant, what is not relevant. Yeah. Yes.
Okay.
Say, please.
Same day, I request the money for 14, and they give the money by 16. Exit from same treasury, every the same market, everything same.
Okay.
14 to I get the money in 16. I can attach the bank statement for proof that treasury same, everything same for same transaction.
All right.
Equal.
The only thing is for me is confused when Mr. Walid says they have to do it within 3 days. Then it seems to me the counsel of the defendant was doubting this 3 days where it's come from, and you said you have an agreement for 3 days. Maybe you want to clarify this. The agreement was written agreement 3 days or just verbal agreement?
No, the written agreement.
In 3 days. Okay. If it is written, then your counsel can address me on this when he do his closing submission and related to some agreement. Okay, I think Mr. Walid, thank you for your time.
Thank you.
And you may dismiss now. Thank you.
Thank you.
Okay, who's next?
It's
your witness.
Thank you, Your Honor. It's my witness.
Yes.
It's my
Please,
witness.
if you can call him. Yeah.
So yes, we'd
Mr.
like to
Walid, you
call.
can switch off the video.
Yeah. Okay.
If we can please ask Mr. Muattaz Al-Maghrabi to switch on his camera and his microphone.
Yes, he may.
Mr. Muattaz, please. Yes, very good. Can you unmute? Thank you, Mr. Muattaz.
Then the registry, yes, alaikum salam. Registry will give you instruction now.
Good morning.
Sorry?
Can I please confirm whether you'll be swearing on oath or by affirming?
I will be swearing by oath.
Thank you. Can I please confirm that you have the Holy Book with you?
Yes, I do.
Thank you. Can you please confirm your name and occupation for the court's record?
My name is Al-Mu'taz Billah Muhammad Hilmi Maghrabi. I am an executive director at Banque Misr.
Please repeat after me.
Sure.
I swear by the Almighty God
I swear by the Almighty God,
that I will say nothing but the truth.
I will say nothing but the truth.
Thank you, Your Excellency.
Thank you. Yes, Mr. Muhammad.
Thank you, Your Honor. Mr. Muattaz, could I ask you to turn to your first witness statement, which is on page 205 of the trial bundle?
Yes.
Please, can you confirm that you are employed by the defendant in its International Wealth Management Division?
I do.
Yes. Can you please go down to page 212, the last page of your statement of truth?
Yes. Yes.
Please, could you confirm that the facts stated from pages 201 to 212, being your first witness statement, are true to the best of your knowledge and true to the best of your knowledge?
Yes, they are.
Please, could you confirm that that is your signature affixed on page 212?
Yes, it is.
Could I also now take you to page 200?
Sure.
And this is the reply statement. Please, could you go to the last page of that witness statement, which is on page 204?
Sure.
Can you please confirm that that is your signature affixed at the bottom of the page?
Yes, it is.
And that you believe the facts stated within this witness statement are true to the best of your knowledge?
Yes, it is.
Your Honor, I'd like to submit the witness statement of the defendant and the reply witness statement of the defendant as evidence in chief for the defendant.
Thank you. Yes.
Thank you.
Yes, Mr. Santoni. Yeah.
Yes. Good morning, Mr. Muattaz. I hope I'm spelling your name correctly. I mean, pronouncing your name correctly. Mr. Muattaz, right? Yes, you're in mute. Yeah.
You are muted.
Yes, now I'm on, yes.
Yeah, thank you. Thank you. Please come to page 205, your first witness statement.
Okay. Which paragraph?
Paragraph 24, which is at page 208.
Paragraph 24, okay.
Yeah. So you have mentioned here, I believe that the claimant asked me to effect its exit from the first and second investment on or about 14th March 2022. Have you found it?
Yes, yes, I found it.
Okay, thank you. So by using the word believe, did you have any doubts that it was not a confirmed or direction or confirmed instruction from the claimant?
No, I received it. Maybe, yes, I did nothing. And I believe that the claimant asked me to effect his exit.
So you're confirming that the claimant asked you to effect its exit from the first and second investment on or about 14th of March.
Exactly as it's mentioned in my statement.
Thank you. So kindly come to the exhibit which you mentioned in this is at page 235. If you can come to page
Number what? Because I don't have them numbered. So if you tell me which paragraph?
Page 235. Come to see in para 24, you have mentioned exhibit EMMH1-05. This exhibit is at page 235. So please come to page 235.
Okay.
So it's taking some time to open. Yeah. So and go to page 236, the next page.
Okay.
This is an email from you stating, "Dear Mr. Walid, kindly find below exit calculation for your mentioned client."
Yes.
Right? Yes. So in this exit calculation, can you confirm the exit date?
This is the one in July, yeah?
If you this is the email from you on 14th March 2022, where you are providing the exit calculations to Mr. Walid or the claimant, and there is a box here where both the transactions are mentioned: booking date, booked rate, maturity, and exit date gross. You found it, right?
Yes.
Yes. So can you confirm from this document which is the exit date that you have confirmed?
I confirmed that the exit date, it was not yet confirmed. It's the indicative exit date is 17th of March.
When you say it was not yet confirmed, can you kindly clarify where it is not confirmed in this document?
Because it says here, it says nothing that the whole exit T-bill exit calculation for
Yeah, I'm not asking about the
exit
calculation. I'm asking about the date.
Oh, the date I told you it's 17th of March. Yes, but it's indicative.
Yeah. Thank you. So noting, it's written noting that the whole EGP TB exit calculation for early redemption is subject to change upon market conditions.
Yes.
So can I ask you that this means that the exit calculation, the amount can change subject to market conditions?
The whole exit calculation, including the date, including the ethics, including everything.
Have you mentioned somewhere in this document that the date is also subject to change?
It's the whole exit calculation.
So according to exit calculation includes exit date, booked
everything,
rate,
the whole
rate,
exit
everything.
calculation. So even the USD number, it might change completely, 100%.
Okay. So again, let's go back to page 210 of your first witness statement.
Okay. Which paragraph? Sorry, because I don't have them numbered. So if you tell me the paragraph.
Okay. Paragraph 35 and 36.
In my first witness statement?
Yes.
Sure. Yes, I have.
Yeah. So here you are mentioning at paragraph 35, at the time that the claimant was exiting the investments, the prevailing market condition affecting Egyptian financial markets was the mass withdrawal of hundreds of millions of US dollars from Egyptian treasury markets in response to the Russian invasion of Ukraine, as reported in the article attached at Exhibit EMMH1-08. Now, Exhibit 08, this particular exhibit is at page 249. And in paragraph 36, you are mentioning Exhibit 09, which is at 254. First, I'll be asking you mainly on page 249. So at page 249, this exhibit is there, which is a newspaper publication.
Yes, from Reuters.
Yeah. One second, it's opening. It's taking some time. Yeah. So if you have opened it, can you confirm the date of the newspaper publication?
The date of the publication is 2nd of March.
2nd March 2022.
Yeah.
So especially with respect to this particular exhibit, when the claimant approached you on the 14th of March for exiting the investment,
sure,
did you inform the claimant that the risk which he was carrying because of this newspaper publication or any other reasons, that it will not be possible for you or the bank to credit the amount on 17th of March or any other date?
It's a general knowledge, yeah. It's already mentioned everywhere. Yeah, it's not something secret. It's everybody know that there is a Russian war. I mean.
So the question, Mr. Mu'taz, did you Did you advise the client about this risk specifically, or you didn't?
Yes, sir. It's already mentioned to the client since the beginning, from day one, that the product itself is
Again, I think the question is, when he trying to do the exit, did you communicate with him? There is any advice being delivered to the client? I think this is the question.
Yes.
Nothing. No, I did not mention anything to the client regarding this, honestly.
Yes, thank you.
Thank you. Thank you. So, general question now. Kindly confirm what was the exchange rate on 17th March, which prevented you from crediting the amount to the claimant?
I'm sorry, come again.
On 17th of March, which was the exit date written on that exit document which you forwarded to the client,
Yeah.
what was the exchange rate prevailing on that day, which prevented you from
It's
crediting
mentioned
the
here,
amount?
it's 15.74. This what you mean?
I think I'll explain to you properly, probably. I'm not very clear. On 17th of March, which was the alleged exit date, because you are challenging that, you're saying that exit date is also subject to change. So what was the exchange rate for this particular bond or particular investment on 17th of March, which stopped you from crediting the account of the claimant? Was it less? Was it more? Was it more harmful for the claimant or beneficial for the claimant?
Okay, to answer your question, this bond or T-bill doesn't have exchange rate. The exchange rate is on the currency. So the currency exchange rate at this time, it was 15.74 as mentioned.
So still you did not credit the amount.
It's I don't get your question, honestly. What do you mean by not credit the
If the
amount?
rate remains the same as it was on 14th of March, what prevented you from crediting the amount on that date?
Because it's upon availability, yes. It's upon availability. It's emerging market product that you have.
Availability of US dollar, you mean, right?
Of the dollars, yes, sir.
So that's the main reason, not the change of the rate.
No, yes, not at all. Not because of the rate. It's because of availability.
This is what is this right, Mr. Counsel? This is what you like to hear, or?
Yes. So if you are saying US dollars was not available on that particular day.
Yes. From our counterparty.
Okay. So and neither was it available till the 23rd of March.
This is the date that we bought the dollar from Egypt. Yes.
On 23rd of March.
On the day that I don't recall really the date, but on the date that the client has received the fund in his account.
Okay. Have you mentioned this, that you had purchased the dollar on that particular date or any particular date, because you're not sure whether it was 24th or 23rd? So
that wasn't part of his statement?
No, so it's already mentioned in the statement.
Can you show where is it mentioned, in which part of the statement?
In 28, in my witness statement on paragraph number 28.
First witness statement?
Yes.
1 second, we'll open.
Which how can I find this? Which page number?
The first witness statement is at page 208, and
208.
paragraph 28 will be. Paragraph 28 is at page 209.
Yes.
So you have mentioned at para 28, the exit from the investments was completed on 28th March 2022.
Yes.
Actually, the exit happened on 24th. It is my belief that the delay to effect exit, I'm saying you have mentioned here on 20, the exit from the investments was completed on 28th March 2022. It is my belief that the delay to effect exit was due to prevailing market conditions, which I describe in further details in paragraphs 35 and 36 of my witness statement. So you have not mentioned anywhere that on which date you purchased the USD and handed it over to the claimant.
The same day it was credited in the account of the client. This is the date that we bought the USD from Misr.
So, but you have not mentioned some anywhere. That is what the question was.
So let's to be in the same page. So can you give him the question you want him to answer right now?
Yes. Mr. Mu'taz, you had mentioned that the amount, of course, we all of us know it was credited on 24th of March. So you said whenever you purchased it, you gave it on that same date.
Yes.
So have you written anywhere in the witness statement or in the particulars of claim, in the defense, that on 24th of March or on 23rd of March, whichever date, I don't know, you received the gold, you received the USD dollars because it was not available earlier on, and immediately you credited the amount.
So I don't get the question. Can you please tell me the question again?
Well, you mentioned that as soon as you received the dollars, the account was credited, right?
True.
So did you mention anywhere in your witness statement or in the defense on which date you received the US dollars?
It's mentioned clearly here. It's exit from the investment was completed on the 28th of March. It is my belief that the day to effect exit.
He's not asking you about the exit. He's asking you when the bank received the dollars,
Yes,
which
sir.
was in short. Yeah, I think what he's trying to say, there is no any statement here in your witness statements confirm that you receive the dollars on this particular day. Is not mentioned here. The only things mentioned that the exit was completed on the 28th of March, but receiving those dollars in short wasn't in particular day. So you are now assuming, you are telling us, you are saying we receive it on the same day we execute the exit. This is what you are saying, right?
Yes.
And the council was trying to find that particular fact within your witness statement, and it wasn't mentioned there when the bank received that US dollar. That's it.
I don't have in the statement.
Yes, this is what we're trying to say. There is nothing in the statement suggests that the bank received the US dollar in any particular day. This is what the council trying to clarify.
Nothing. Yes.
Okay.
Yes.
Thank you. So starting from 17th of March till 23rd of March or till 24th of March, was there any communication from you, from the bank, to the claimant stating that we have not received the US dollars and so we are unable to credit your account immediately. As soon as we receive, we will credit.
The client truly, yes, he called me several times and he was asking about the exchange and the money. And I told him that we are waiting for the central bank to get the dollars to be credited in your account.
So you admit that the client called you?
Yes, he called me over the phone, yes.
Thank you. Even you have also, it's part of the record that there was a notice sent by the claimant on 23rd of March asking for the payment, and you have a response also, which is at page 244.
Which paragraph?
I'll mention you, just 1 second. Yeah, it's a small response from your side.
Okay.
Page 244.
Email that I have sent to the client, you mean?
Yeah. It was a letter dated 23rd of March 2022. Exhibit, your exhibit EMM H107 at page 200 and starting at page 243. And the letter, the main contents of the letter starts from page 244. This is in response to our clients, to the claimant's notice of 23rd of March asking for the payment.
Okay.
Yeah.
This was mentioned. This is the legal reply.
Correct, correct. And so I'll just ask you the question from here.
Okay, sure.
Yeah. In this letter also, did you mention anywhere that on 17th of March you could not deposit the amount to the client's account because of unavailability of the USD dollars?
I'm sorry, but what is the question?
In this letter, is there anything, any paragraph, any sentence which mentions the non-availability of US
لا ما هو
dollars?
why are you asking me? I'm sorry to tell you this, but I was not the one who wrote this letter. This letter was wrote by the legal on the client's letter that he sent. So this was a simple reply, legal reply, has nothing evidence or anything that says any reply or legal or fact reply. It's only a reply against the client letter that he sent to the bank. That's it.
So, but you have relied, this is a part of your witness statement. This is your exhibit.
Sure.
So then you need to reply. What are the contents of this notice?
Sure.
You have already verified in your witness statement that you have read and understood the contents of this letter. And
sure.
so it's a simple question from the letter. Please show us.
Can you repeat the question again?
Yes, Your Honor. The question is, in this letter, whether the bank, through either Mr. Muattaz or through the legal representative, whoever they are, have confirmed the non-availability of USD dollars, which led to the non-credit of the account of the claimant.
يعني if I can read for you here, it says أحوال السوق قد تجعل من المستحيل أن يتم تنفيذ تعليمات غلق الاستثمارات فورا.
If you read the English part, it will be easier for me. I don't understand Arabic.
I don't have the English part.
It's part of the trial bundle.
Okay. Yes, I found it.
Yeah.
It says here that in order to close the investment, the client might suffer a big loss. In circumstances, if market might change, it's possible to perform the instruction of closing the investment immediately. All these clauses are coming exactly from the agreement the client signed.
No, my specific question was the unavailability which you are telling now that the USD dollars was not available. Was that mentioned in this letter? That is the.
Oh, it's part of the market circumstances, my sir. It's part of the market circumstances.
That's a very wide term.
Circumstances of the market might make impossible to perform the instruction of closing the investment immediately. So this is exactly saying the same answers your point. The market circumstances made it impossible to close the investment immediately.
So you are saying the market conditions need not be explained. What can be the market conditions which makes a job impossible or frustrating a job totally?
It's not a job, it's investment opportunity, it's investment.
No,
it's
that's
investment.
a legal
So
word.
the investment will have some aspects that controls it, yes?
So you agree to it that the word unavailability of USD dollars is not present in this letter?
It's part of the market circumstances.
Okay. Okay, I'll have two more suggestions, and these are not questions. The first suggestion to you is you were waiting for the calculation or the value of the investment to deteriorate further to enable crediting a minimum amount under the garb of market conditions.
I'm very sorry, but I didn't really get your question here. Can you please tell me what's the question?
Yeah, it's not a question, it's a suggestion.
So what is it?
Suggestion is whatever the exit calculation was done on the 14th of March, 2022, you deliberately waited so that it goes down further and then under the garb of market conditions, you deposit a much lower amount.
So this is a suggestion from your side.
Yeah.
So you want me to say what?
Well, whether I mean, well, if you want, if you would, of course, whether you're going to say I agree with this, I disagree with this is up to you. I mean, this is just a suggestion. He's trying to summarize the position of the bank.
لا يعني it's very
Oh,
obvious.
you want to answer this? You don't want to answer this? Up to you. It's not a question. It's a suggestion.
It's conjecture. يعني
Yeah, but what's your answer? Are you agree? You disagree? You don't want to answer this? Up to you. You are
it's
the
very
witness.
obvious. It's very obvious, Your Honor, in the email communication, the dates, everything. It's already mentioned in my statement.
Okay, let's move on.
Okay, the last suggestion, and I'll not, after this, we can close this evidence, unless Mr. Mahmoud wants to question something. Last suggestion is that the bank has failed to discharge its obligations and duty towards the claimant and is guilty of gross negligence and is liable for not only payment of the shortfall amount, but also damages along with interest because of your negligence.
I disagree on this.
Thank you. That's all, Your Honor.
Yes. Mr. Muhammad, do you want to have any question for your witness?
Yes, Your
please.
Honor. Thank you. Thank you, Mr. Mu'attaz. Mr. Mu'attaz, how many years have you been a relationship manager with? How many years have you been a relationship manager, either with Banque Misr or in the banking industry?
And I have an experience of around 19 years.
19 years. And in 19 years, has anybody accused you of being negligent?
If anybody, sorry?
In 19 years, has anybody accused you of being negligent in your work?
No, never.
Very good. And in relation to this vision construction in particular, was it you who were suggesting investments, or was it vision construction as represented by the gentleman's name escapes me,
Walid.
Mr. Waleed, or was it Mr. Waleed who was directing you to do things?
No, actually, Mr. Waleed, he approached us, or me particularly, through a common friend, and he was looking to invest in Egyptian treasury bills.
So you weren't trying to actively solicit business from him?
No, not at all. He approached us directly.
And you were not advising him on any of his investments outside what was written in terms of the general risk disclaimers, is that right?
No, not at all.
Okay, that's all, Your Honor. Thank you.
All right. Thank you, Mr. Mu'attaz. You may dismiss now.
Thank you, Mr. Thank you, Your Honor. Thank you so much.
Thank you. All right. Is 1 hour and a half. You want to take a short break or you want to continue? It's up to you.
So may I just confirm from take instruction from the solicitor if the expert is here. So
are they here?
Let me check. I'll just
yes, please go ahead.
We finished quite quickly, actually.
Yes.
Right. No, we still have a closing submission.
Yeah.
Honor, I would ask if I could get a few moments to use the washroom.
Yeah, exactly. So that's what I'm suggesting. So shall we come back on 11:45?
Yes.
Yes, please.
Okay. Thank you.
Thank you.
Good afternoon, Your Honor.
Yes. So your experts here.
I don't think he's there, so we have to proceed without him.
Is it okay now?
Yes, Your Honor. Yes.
Yes, Your Honor.
Okay, so let's proceed without him.
Yes. So,
but I just want to make sure he was aware of today's hearing and he was.
Yes, he was present in the morning, and then I really don't know what happened, and so.
So did you call him and he said he wouldn't be able to attend, or he didn't respond?
No, Mr. Walid called him, and yes. He said he had several other meetings lined up. That's why he was requesting in the morning. But rules are rules, so obviously
So he's voluntarily he don't want to attend.
Yes.
And the reason why he have another meeting to attend. So he gave priority for other stuff rather than this hearing.
Yes, Your Honor.
Okay. Just want to be this on the record.
Yes.
Any observation, Mr. Muhammad?
Well, Your Honor, as you know, the claimant, the defendant hasn't had the opportunity to cross-examine the expert witness on any of the matters that he's presented. So the defendant would submit that the expert report would have to be excluded from the record.
Yes. Okay. Fair enough. We'll deal with it later on. So please proceed then with the closing submission.
Your Honor.
Yes.
Yeah.
So there are no disputes about the invested amount and the exit calculation, the date as on 14th March 2022. So my submission is the entire dispute starts from 17th of March. Till that, the claimant also agrees that he has signed the master agreement, he has signed the risk disclaimer, he knows it. And there is an exit calculation which the defendant has also submitted, which was accepted by the claimant on 14th of March, which mentions that 17th of March would be the exit date, and the particular amount is also mentioned in that. Now, what happened on and from 17th of March 2022? First of all, these two transactions which are admitted by both the parties are at page 141 and 143 of the bundle for your lordship's record. The exit emails are at page 151 to 161 of the bundle. Now, let us have a look at the master agreement and the risk disclaimer agreement. So, your lordship, I'll take you to page 226 of the bundle.
Yes, go proceed.
So it's opening slowly. Yeah. Yes. There are two definitions which require attention. One is market risk and foreign exchange risk. That's our submission. Market risk says market movement which can be influenced by many factors, including but not limited to credit risk, market sentiment, changes in value and volatility of any underlying assets, and changes in economic, financial, or political environments may result in the fluctuation of prices. Market risks result from the unpredictability of market movements and is inherent in any investment. Such risk may cause the value of the investment to fall rapidly as well as rise, and investors may not get back the amount originally invested. So the crux of the entire paragraph under market risk is it may cause the value of the investment to fall rapidly or as well as rise, and investors may not get back the amount originally invested. Now, foreign exchange risk, changes in exchange rates between currencies or the conversion from one currency to another may cause the value of the product to diminish or increase. Currency exchange rates may fluctuate significantly over short periods of time. Earnings on investment in foreign currencies are dependent on the prevailing foreign exchange rate. Adverse exchange rate movements may erase interest earnings completely or cause loss of principal relative to your home currency. Investments in assets denominated in a foreign currency are subject to the risk of movements in that currency's exchange rate. The exchange rate risk on investments in foreign currency denominated assets applies not only to investments returnable in these foreign currencies, but also to the assets denominated in the foreign currencies and traded in the domestic currencies, since their price development usually tracks changes in the exchange rate of the currency in which they are denominated. So my understanding from these two definitions is, whether it's market risk or foreign exchange risk, the value of the investment might go down or it might go up also. Now, both these factors, foreign exchange risk or market risk, do not imply or indicate that the date on which the amount should be refunded or credited also changes. It is the value of the investment which can change. We do not know what the amount would have been had it been credited on 17th or before 24th. There is also no evidence or pleadings by the defendants that dollars was not available on that particular date, 17th to 23rd. They have made a statement in the witness statement while cross-examining the witness of the defendant, but no evidence has been provided. Now, coming to the master agreement, we are relying on, please come to page 214, Your Lordship, 214.
Yes, yes, I'm following.
Yes, I'm just opening it. We are relying on clause 5.1 at page 219. The heading in 5 is illegality, impossibility, force majeure, and introduction of new taxes. So 5.1 reads, if by reason of act of state or force majeure, either party is prevented from making or receiving payments or deliveries in respect of a transaction, or from doing so on time, it's very specified, or from doing so in time, or if any provision of this master agreement or any transaction under this master agreement or the performance of any obligation in respect of a transaction becomes illegal or impossible, either party may by notice, again the word is here may, by notice to the other party terminate any of the affected transactions, but not this agreement as a whole, in accordance with sections 4.7 and 4.8. Now, if you read it again, so it says by act of state, the defendant have already submitted a document, a newspaper report about the Ukraine war, Russia war and everything. So of course it falls under that parameter, act of state. Now this 5.1 needs to be read with 4.7. It is at page 218, the previous page. May I continue, Your Lordship? Yes.
Yes, please go ahead.
Yes. So if any event of default, as 4.7 reads, if an event of default is as specified in section 4.4 or 4.6 has occurred with respect to a party and such event of default has not been remedied, the non-defaulting party may terminate all transactions entered into under this master agreement by written notice to the other party. Such notice shall either have immediate effect or shall be effective as of the date specified by the non-defaulting party in such notice. If notice to terminate this master agreement is given, any payment obligations, deliveries of underlyings, or posting of collateral that would have become due on or after the termination date are no longer required to be made. These obligations shall be replaced by the obligations set forth in section 4.8. 4.8 is not relevant here. The point here is, in the case of a default under 4.4 or 4.6, if the non-defaulting party terminates the agreement, then any payment due prior to the termination date has still to be made. So 4.7 now needs to be read with 4.4, which is on the same page. No, sorry, 217, 4.41 particularly. So 4.4, if any one of the following events occurs with respect to a party in connection with a transaction, the other party may terminate the transaction under this master agreement pursuant to 4.7, which we just read before. Now 4.41, failure by a party to make any payment when due or to deliver any underlying owed under this master agreement to the other party if such default lasts more than 3 bank business days. In the cross-examination of the claimant's witness, Mr. Walid was referring to 3 days. I believe he was referring to this 3 days, though probably he was not able to explain in the manner he wanted to explain. Our submission is 17th of March 2022 was the exit date. In terms of 4.4, 4.7, and 5.1, reading backwards, cutoff date should have been 28th. If there are 3 working days, if there are more than 3 working days, then it can be extended by 1 or 2 days. In the absence of crediting the amount or complying with the obligations under this master agreement of paying a certain amount within those 3 working days or banking business days, it's a clear case of default. Whether or not the non-defaulting party is terminating the agreement, that's irrelevant here, because irrespective of termination, any payment due prior to the termination is due. So our submission is the default is complete once that 3 days is over, 3 banking business days. The option of termination is open. The payment obligation still remains because it is prior to the termination date. So my submission is that post 17th of March, as there was no clarification from the bank and no explanation by any form of communication, whether email or any sort of letter, the letter which the defendant is relying on is a response to the letter from the claimant, and it does not explain anything. So there was no communication stating why there is a delay. They have harped on the issue of non-availability of USD. There is no evidence to that effect. The expert report, which probably ultimately your lordship may not consider, at page 275 of the expert report, he has mentioned that $37 billion was available with the Treasury at that point of time. The defendants had a copy of the expert report from the very beginning till since the case was filed. There was no response to that. I'm not relying on the expert witness now because it has not been proven by the examination in chief. But for the case, at least for the case of reference, I'm saying that there was no reference, there was no objection to that report, where it specifically mentioned in the last page of the expert report at 275 that 37.1 billion USD was at that point of time available. So no contrary evidence has been given, neither any evidence has been given by the defendant stating that USD was not available. There is another point where in the cross-examination of the claimant's witness, he was asked to prove whether he had called the defendant. While in the cross-examination of the defendant's witness, the defendant has admitted that. So the final submission is, in terms of the master service agreement, as well as the risk disclaimer, there is a clear breach of contract in terms of clause 5, article 5.1 of the master agreement read with 4.7 and 4.4. The risk disclaimer applies universally to all agreements, but that doesn't mean that it overrides the master service agreements clause 5.1. Now the articles and authorities which I have relied on to prove that it's a clear case of breach of contract and negligence starts from page 282 of the trial bundle. I'll take your lordship to page 283, where I have set out the relevant provisions of DIFC law number 6 of 2004, article 10, binding nature of contract. A contract validly entered into is binding upon the parties. It can only be modified or terminated in accordance with its terms or by agreement or otherwise provided by in this law. This not only applies to the master agreement, it also applies to the confirmation dated 14th of March from the defendant as to the amount as well as the date. There was no subsequent amendment or no subsequent communication from 14th of March till 24th or from 17th of March till the 24th as to the change in date or change in amount. Then coming to Article 15, a proposal for concluding a contract constitutes an offer if it's sufficiently definite and indicates the intention of the offerer to be bound in case of acceptance. Now, Article 50, interpretation of statements and other conduct. The statements and other conduct of a party shall be interpreted according to that party's intention if the other party knew or could not have been unaware of that intention subject to Article 53, 50 within brackets 3, if Article 50 subclause 1 is not applicable, such statements and other conduct shall be interpreted according to the meaning that a reasonable person of the same kind as the other party would give to in the same circumstances. So the point here is, by their conduct on 14th of March, on 17th of March, until 23rd of March, the defendants have made it clear that there is no change in the contract terms as on 14th of March 2023. Exit date remains the same. There was no communication for any change in exit date, neither there was any communication about the change in amount. The client or the claimant was not even advised or asked that if we liquidate on 24th of March, you will be suffering a huge loss compared to what you have already accepted on 14th of March. Article 51, or rather Article 57, implied obligations at page 284 arise from the nature and purpose of the contract, practices established between the parties and usages, good faith and fair dealing, and reasonableness. The submission is the entire dealing has not been done in good faith and it's not fair, neither is it reasonable. Article 59, Article 77, non-performance defined. And also 64, a party must perform its obligations if a time is fixed by or determinable from the contract at that time. If a period of time is fixed or determinable from the contract at any time within that period, unless circumstances indicate that the other party is to choose a time. In any other case, within a reasonable time after the conclusion of the contract. So here again, Article 5.1 of the Master Agreement comes into play, where it clearly says that there are 3 banking business days within which, if the money is not given from either party, whoever has an obligation to do it, then that's a clear breach of contract and that's a clear case of default. And Article 77 says non-performance is failure by a party to perform any one or more of its obligations under the contract, including defective performance or late performance. This is certainly a case of late performance, which has resulted in a shortfall amount being credited to the account of the claimant. Article 109, right to damages. Any non-performance gives the aggrieved party a right to damages either exclusively or in conjunction with any other remedies except where the non-performance is excused under the law. Now, the computation of the loss, as I submitted in the beginning today, that it was only submitted on 27th of June. So I leave it to your lordship. Your lordship will take a decision how to deal with that. Article 110, measure of damages. Subject to the limitations in this part 11 of the law, the injured party has a right of damages as measured by the loss in the value to him of the other party's performance caused by its failure or deficiency, plus any other loss, including incidental or consequential loss caused by the breach, less C, any cost or other loss that he has avoided by not having to perform. So this is directly linked to the application which has been filed lately on 27th of March, 27th of July, June. And then again, Article 119 talks about interest and damages. I've relied on the following precedents where Carlyle versus Carbolic Small World deals with a binding contract objective test. RTS flexible, again, the determination whether the parties intended to create legal relations and agreed on essential terms relies on their communicated words and conduct. In this case, the conduct has been on part of the defendant, total silence, starting from 17th till the 24th. Rainy sky, also a contractual interpretation, aims to decipher what a reasonable person equipped with all relevant background knowledge would understand the contract language to mean. So in this case, if it is argued and the claimant knew about the risk, yes, he knew about the risk. Even knowing about the risk, he knew that even if he gets the amount on 17th, he will be getting less than what was invested. He was okay with that. He never said, no, I don't want to get it. Just give me the money, whatever it is on 17th. But the money was not given on 17th, and so the loss was more and no communication was made. Then the relevant provisions of DIFC law number 5, that is law of obligation. Article 10 is causation. To establish liability under this law, a claimant must show that, but for the defendant's conduct, would not have suffered loss, and the defendant's conduct was a substantial cause of his loss. So of course, again, the new application which has been filed last week again comes into play, but it's obviously clear that if an amount of $300,000, less $300,000 is there, so there has to be a loss. Now, point number C, relevant provisions of DIFC law number 7, law of damages and remedies, right to damages, any non-performance, it's Article 8, gives the aggrieved party to a right to damages. As this I've read before, I think it's a repetition, I believe. So Article 23, right to damages, the breach of an obligation on the law of obligations gives the injured party a right to damages to compensate the injured party for the losses, pecuniary and non-pecuniary, sustained as a result of the breach. The right to damages can either be exclusive or in conjunction with other remedies. Going down at page 287, I've relied on some precedents where in Salim Dwala, the claimant had sought recession of the SP and full reimbursement and compensation. It was held that the court could order rescission with restitutio in integrum under Article 35(1) of damages and remedies contingent upon the claimant proving his misrepresentation case, etc., and requesting such an order. Probably this will not apply to that effect. Amira Foods observed that Article 12 of the Law of Damages and Remedies mandates the court to evaluate the foreseeability of loss due to a breach of contract at the time of non-performance, diverging from the common law of U.A.E. Law and U.A.E. law, where foreseeability is evaluated at the contract's inception. Principles of estoppel certainly lies because the defendant, while keeping quiet during the entire period starting from 14th of March till the 23rd of March, cannot now take the plea without any evidence that there was no funds or no USD dollars available with them. That is a plea which has been taken lately without any substantial evidence. So the principle of estoppel lies there. The following precedents support that: Tinkler versus Commissioners and Globement and their development. The objective test in contract and agreement and implying terms at page 288, existence of a binding contract is determined by an objective test which assesses whether, based on the evidence, a reasonable person would conclude that the parties were in agreement and intended to create legal relations disregarding the parties' own views. The contract is sufficiently certain to be enforceable. Indicators of the parties' agreement include a concluded bargain, which is clear in this case. All necessary terms are settled, leaving nothing to be agreed upon. That is also cleared. Any remaining determinations do not depend on further agreement between the parties. The defendant might argue point number 3 attracts risk disclaimer, but again then clause or Article 5.1 the master agreement overrides the risk disclaimer and it has full effect. There are some precedents which support this: R&D Construction, Hillers and Company, and Mamidol, Jitol, Greek Petroleum, and Brook Homes. In conclusion, Your Lordship, we submit that based on the master service agreement, based on the risk assessment, which only talks about the valuation of the amount, the computation, not the date, the claimant is entitled not only to claim shortfall amount, but also interest, as well as damages on account of loss suffered by the negligence of the defendant. And the defendant be stopped from taking a plea of risk disclaimer as the defendant failed to notify the claimant of any changes in the exchange rate or any circumstances which is preventing them from crediting the agreed amount on the 17th of March 2022. In the light of above, we pray that the claim be allowed with costs on the defendant and also damages be allowed. Your Lordship, that's all.
Yes, thank you. I would like to ask you, where is this reference for the 3 days the witness was referring to?
Yes, I will again take you to, Your Lordship, to the master agreement.
Mm-hmm.
It is at page 214.
214.
Yes.
214.
And the relevant page is at 217.
Master agreement 217.
217, then paragraph 4.4.
Wait a second.
If any of the
4.4.
following events occurs with respect to a party in connection with a transaction, the other party may terminate the transaction under this master agreement pursuant to section 4.7. 4.41 says failure by a party to make any payment when due or to deliver any underlying owed under this master agreement to the other party if such default lasts more than 3 bank business days. So if it is more than 3 banking business days, then either of the parties have the right to terminate the agreement, and it's a clear case of default. So assuming that 17th March, it's not as assumption, it's a clear case. The 17th of March was the exit date. Both the parties have agreed on it. So at the most 28th of March or 21st of March, if there is a holiday in between. Beyond that, it's a clear case of default. So this is my submission with respect to what the claimant's witness submitted with respect to the 3 days.
But I noticed this is referring to termination, not to execute the transaction. Right? This is the period for termination.
No,
So you
yes,
might come and terminate, or the bank would say, I'm terminate this agreement, but not to perform. So there is no an obligation on the defendant to do what he's been asked to do within time frame being 3 days.
no,
This
the
is
obligation is
what you are suggesting.
Yeah, so the interpretation which I am trying to submit before your lordship is it's a failure in terms of 4.41. It's a failure by a party to make any payment within 3 business days from the date agreed, which allows the other party to terminate the agreement. So if the other party does not terminate, then or terminates, either ways, the obligation remains for payment of the amount as agreed on the exit date. So if the bank does not pay also within the 3 days, fine. That does not mean that even if they pay after 20 days, they will not pay the amount which was agreed on the exit date.
Okay. This is your interpretation of the...
Yeah, this is my interpretation, Your Honor.
Yes.
Yeah.
Okay. Thank you. I don't have any further question for you. Shall we go to Mr. Muhammad?
The only just
Sorry.
one point, Your Lordship, before just one point regarding this default clause of 4.41. If we see at 4.7, which is the main clause which ultimately leads to 4.41. 4.7 is at page 217, which says, and the second part of the clause 4.7, 4 lines starting from the top. If notice to terminate this master agreement is given, any payment obligations, deliveries of underlyings or posting of collateral that would have become due on or after the termination date are no longer required to be made. So that means anything which is due prior to those 3 days or prior to a termination, if affected, shall still remain due. That is my submission.
So did the claimant serve the termination notice after those 3 days?
No, we did not terminate. It's a clause which is under the word may. So
Yeah,
it's
I
not a binding obligation. So, but that does not mean, according to my respectful submission, is that even if they do not terminate, the obligation disappears as far as the amount is concerned and the exit date is concerned. The main case or the main submission was 17th of March was the date when the money should have been refunded. It did not happen. So we do not know what was the exchange rate or what would have been the amount of money if it had been submitted on that date. It happened on 24th after almost 8 days. So that is the main case. So no communication was provided. Why there is a delay? Now they are coming up and saying there were no USD. They did not even respond to the expert's report at page 275, which says that $37.1 billion was there with the Treasury. There's no written response. That's all.
Yeah, my point, if the claimant believes there is an obligation on the defendant to execute the request within 3 business days, then why the claimant didn't fulfill his right to terminate the master agreement after the 3 days?
Because I believe the claimant was more interested in getting the money quickly, and that's why there was a notice dated 23rd March that this is the last warning, or this is the warning letter, please fund the money. I agree that he did not specify the particular clauses or did not mention in the letter within 3 days you did not, so I am terminating if you do not pay it now also. I agree there is no such direct specific clause there, but still there was a letter on 23rd asking them to refund. Apart from that, there was a meeting also on 18th and 19th, which the defendant's witness accepted today while cross-examination.
No, he didn't accept the meeting. He says, I received call.
Yeah, I received
I
the call.
don't think he accept any. There is no any reference in his witness statement says I met with the.
He mentioned there was a call from the claimant's witness,
Yeah, but
Mr.
there is
Waller,
there is
asking
no.
about the money, when it will be refunded.
All right, I will leave this for the defendant counsel to highlight. Okay,
Yes.
thank you, Mr. Santo. Thank you.
Thank
Please,
you,
Mr.
Lord.
Muhammad, go ahead.
Thank you, Your Honor. I'd like to start the the closing statement by addressing some of the points that were raised by Mr. Santanu. Mr. Santanu makes reference to clause 5.1 in terms of reasons of act of state or force majeure. As Your Honor has rightly pointed out, this is, I think, not relevant at all. This deals with termination. This reference to clause 4.1, 4.4, it talks about the termination rights, which, as the court has already identified, no termination was actually, nobody wanted to terminate the agreement or the transactions. This submission that this warning letter amounted to some kind of termination cannot possibly be accepted because the word termination does not once appear anywhere in any communications with anybody. And that includes this supposed meeting that took place in person, which again, the defendant and the court, as the court rightly pointed out, the defendant never admitted to. So the defendants and the defense takes exception with the idea that the arguing of our position on the claimant to argue our position on his to make our argument. I'm at a loss of words, actually. There's a fantastical interpretation of clause 4.7, which references terminations pursuant to clause 4.4, which, I mean, the court has rightly pointed out it's not relevant at all in these instances. I also wanted to draw the court's attention to the argument placed by Mr. Santanu that no disclosure was made with regards to US dollars and that a shortage of US dollars is not provided for in the general risk disclaimer. This is patently incorrect. I'd like to point the court to tab D3, page 85 of the trial bundle, which is the general risk disclaimer. First of all, the court will note that the general risk disclaimer sets out that it is non-exhaustive. The list that is set out in the general risk disclaimer is for indicative purposes. Also, the court will note that there is there's wording in the general risk disclaimer about liquidity. There's sorry, where's the exact wording? The lack of liquidity and exchange control is provided for in the general risk disclaimers. So the fact that US dollars not being available wasn't a risk that was I'm just pulling up the wording. Sorry. The lack of, sorry, yes, it's on page. It's on page 87. Where it says lack of liquidity and exchange control. Such situation may result in difficulty finding a price offset liability. It goes on. I'm not going to read it. In the second line, in the case of company bankruptcy, suspension of trading, takeover rumors, or flights of capital from a country in crisis, which, by the way, the defendant argues is the situation at hand, this could lead to substantial losses, sometimes greater than the initial collateral placed as security. So the argument that a risk of a lack of dollars was not a risk, was not communicated to the claimant, the defendant rejects this. Now let's turn to the issue at hand, which is what the situation of what has been orally disclosed and admitted by the claimant. Witness for the claimant admitted that it was aware of the market conditions. They've admitted that they signed the general risk disclaimer. They admitted that the investment was one that was made for profit. To use his words, it's traded like gold. It goes up, it goes down. He's assumed that a turnaround time was 3 days based on this misguided reliance on clause 4.4 subsection 1. And the claimant is arguing that the defendant should have notified the claimant. The defendant submits that there is no duty to warn. There is no duty to warn. The defendant, the claimant itself, never sought advice from the defendant. In fact, it was the exact opposite. The defendant or the claimant ordered investments on behalf of the defendant, ordered exits. So for them to now, they've signed up to the agreement. They accept that they signed the agreement. They accepted that there are risks. They accept that that the risk disclaimers were binding. They've made all of these acceptances, and now, as a result of a bad investment decision, the claimant is essentially asking the court to subsidize its loss. It sets a very, very dangerous precedent for the court to issue a judgment whereby a claimant who has not relied on any advice or any guidance from a defendant makes an investment, decides to exit that investment because of the timing of the investment and the market conditions around that investment, is unable to exit in times that are convenient for it, which unfortunately that is not how the markets work. Markets don't work for the convenience of one person. Markets are fluent, fluctuating things. Now, the defendant talks of $38 billion in reserve currency, and that the defendant did not object to any of the factors set out in the expert report. Well, the defendant submits that because we had no opportunity to cross-examine the expert, nothing in that expert report should be given any weight whatsoever. The entire purpose of a cross-examination is to point out the flaws in the expert's report, and it, I think, is a bit presumptuous of the claimant to assume that we did not have a line of questioning on the merits of the expert's report. I also wanted to take a moment to mention something that the witness for the claimant was attempting to talk about, which is this alternative, this investment that was made with another banking institution. It refers to documents that. Sorry, let me just pull it up. In G13, pages 174 to 188, which the defendant respectfully submits are just an attempt to divert the court's attention from the situation at hand. That situation being that this was an investment in Egyptian treasury pounds in US dollars with a credit from Egyptian pounds to US dollars. this transaction with Banque was done. It's not clear, but we believe that it was done in Egypt at the Mansoura branch of Banque de Caire. It was done in Egyptian pounds. And we have no understanding or any view on what the terms and conditions of that investment was. So for them to, for the claimant to refer to this transaction as proof that the defendant delayed in performance is respectfully rejected. It has, you're comparing apples to oranges. There's no relevance in this in this matter. If I can just go back to the expert report as well, that is a fundamental failing with the expert report as well. It talks of things in generic terms without any justification. It talks about high liquidity and US dollar figures without providing any sort of background to this information. It ultimately, what this case revolves around in the breach of contract claim is that, again, we will repeat, there was a binding contract. The claimant has argued the point for us. There was a binding contract, and that includes all of the terms of the contract. That includes clause 7.3, clause 16. It includes the risk disclaimers. They are making the argument that the emails amount to a binding contract. Well, even if that were the case, the emails have terms and conditions, that term being that exits are subject to market conditions. The claimant seems to believe that the exit date of 17th of March was something that was set in stone, when very clearly the defendant has testified that no, when we refer to the whole, we are not referencing just the numbers, we are referencing the whole. So I think it also is quite telling that the claimant has completely abandoned their claim in clause 3.1 and clause 1.6, which was the primary cause of action that they put in their particulars of claim. That 1.6 was a confirmation, that 3.1 that dictated terms for performance, and now that they've completely, tacked on this new claim under clause 5.1 and 4.7 and 4.4 subsection 1, the defendant submits that this clearly demonstrates the grasping at straws for the claimant to find some justification outside of its own bad investment decision to try to reclaw any sums of money from the defendant. On the point of negligence, I think it's particularly telling that they have completely abandoned negligence. They have not made any argument on duty, breach, or causation. They simply have not. Again, it is not for, the onus of proof in proving a negligence claim lies with the claimant. The claimant has not discharged any of the requirements under Article 17 of the DIFC Law of Obligations. Again, this demonstrates that the claimant knows that it has a bad case, knows that it made a bad investment, and is now seeking whatever reason, however desperate it may be, to try to claim some money back from the defendant. On another point, and just in closing, I just wanted to draw the court's attention to one other matter that I feel is necessary to discuss, and that is the conduct of the claimant, particularly in relation to, this will have some bearing as to costs. The claimant has delayed this matter by 2 years. For 2 years, we've been pushing this matter along. At every opportunity, at the last minute, to try to either catch the defendant off guard or to try to delay matters, they have filed applications in the last minute. The defendant does not accept that the application for quantification of damages was filed on the 27th. Quite simply, it does not accept. If that application was filed and there was an issue with payment, as the claimant argues, then as a matter, for arguing good faith, in good faith, they could have reached out to us and made us aware of the application, but they did not. No, instead, less than 24 hours before this case is due, less than 48 hours before this case is due to be heard, we are notified, oh, by the way, these are our damages. So on the point of the conduct of the claimant, I think regardless of the outcome of this dispute, which the defendant steadfastly holds that the claims should be dismissed, notwithstanding that, in the event that the claimant's arguments are accepted, the defendant respectfully submits that the court cannot order costs in its favor. It absolutely cannot. This sends a very, very bad or dangerous signal to claimants to go on fishing expeditions, which is essentially what this case was. This is what the case was at hand. The claimant had an agreement, was aware of the terms, admitted that they were aware of the terms, made a bad investment, lost money on their investment, and are now asking the court to make them whole without justification in any way.
Yes.
In closing, I would also request that the court reread the particulars of the statement of defense and our skeleton argument and the reply to the statement of defense, which sets out in more detail the legal grounds that we base our assertions on.
Would the defendant like to respond to the submission made by the claimant on the loss of damages? Do you want to respond on that by writing or?
Well, we would submit that we would ask that be addressed
before this court going ahead with making a final decision, would you like to have opportunity to respond of what has been submitted to the court last before this hearing, or you reject that at all?
We reject it outright. We reject the application outright. But having said that, we would like the opportunity to set out in more detail why we believe the application should be rejected. So we are making an application. We would request that the court reject it outright, failing which, if the court determines that it needs more, needs more information from us, we will file.
How long you need? 3 days? More than that?
I would submit that we would need about a week, if that's okay. So the 10th
Sure.
of 10th of May.
Yes.
Sorry, 10th of July. My
10th of
apologies.
July. Then the claimant would maybe ask for reply.
Yes.
So how long you need for reply? 3 days?
Yeah, 4 days, Your Lordship.
Right. So we'll give the defendant then the opportunity to reply to the claimant submission made on the loss and damages, followed by another 4 days for the claimant to reply. Then we'll take it from there, deciding on the whole case. All right, so I think it's anything you would like to say before we finish?
Just one clarification.
Yeah.
My learned friend has said that we have given up our stand on Article 3 of the Master Agreement. Article 3 at page 216 of the bundle, it simply says 3.1, each party shall discharge the payment, delivery and other obligations owed to the other party no later than on the due date specified in the confirmation. It's already in the particulars of claim. So there is no question of waiving this right. It is there. So that's all.
Yeah. Comment, Mr. Muhammad?
If it's in the particulars of claim, that's understood. It's in the particulars of claim, but the court will note that all of these arguments on clause 5.1, outside of just claiming article 5.1, this argument on clause 4.1, 4.4, 4.7, 4.8, those haven't actually been mentioned anywhere in these pleadings. So if we're going to be talking about particulars of claim, then let's talk about the particulars of claim and make note of the fact that none of these arguments were placed before.
5.1 probably was there in the witness statement. I'll just check in a second and I'll confirm.
All right. Okay. I would like to thank you, both of you, for your time. And as I said, we'll be waiting around 14 days until we close all submissions. And we'll take it from there. Thank you again.
Thank
Thank
you.
you, Your Honor.
Thank you.
Thank you, Your Honor. Yeah.
Your Honor, if I may,
Yes.
may I also request directions from the court that the claimant file no other applications, that this is the last application?
No, it should be goes without saying there is no any permission to file any other application. He did
Thank you
file
very much,
already
Your
the
Honor.
last application. Now this is your turn to respond to that application, and they will reply to your response. That's it.
Yes, thank you, Your Honor.
Thank you. Appreciate
Thank you very
it.
much, Your Honor.
Thanks.
Thank you.
Thank you.
Bye-bye.
Thank you.